Hey, what's up with it? Past few weeks I've been extremely busy, so my apologies to those I was waiting for that next play. Uh, for starters, I did pick my classes right now for criminal justice. I'm extremely excited about that because my whole plan is to make my way to law school and then double back for my folks in a real way and bring other people along with me that have the same state of mind. Okay, so the federal court, when you file appeal in the federal court, you have to first exhaust your state remedies. The definition of exhausting your state remedies is you cannot argue something new in the federal court that you have not already argued in the state. It is impossible. They'll automatically deny your petition. There's a section on the federal habeas corpus that you'll be filing with your district court that will ask, did you exhaust your state remedies? If no, they're going to ask you why. If the reason isn't good enough, which there isn't a reason good enough, then they're going to kick it back down and tell you to go handle that. So for the most part, when I did my appeal, I sent in my federal habeas corpus to the Eastern District, had everything that I argued in the state court, trial court, California Supreme Court, and then I also attached a notice requesting the appointment of counsel. The case law that I used was Weygank versus Look. I'm not sure on the numbers, but the case is solid. It's Weygandt versus Look, like I'm looking at you. LOOK, for those that may have slipped. That case law, the way that I requested the appointment of counsel is I filled in the blank of saying all the reasons why I'm requesting counsel because the complexity of the issues that I was arguing. It was a Miranda violation. It was ineffective assistance of counsel for trial and my appellate court, falsifying police reports, stuff like that. So I looked up though. Now, when you request counsel, the court has a discretion in order to give you counsel. They have that. If they don't believe that your case is too complex, then they have the right to say no, and then you have to argue it yourself. So I looked up. I was given an attorney by the name of Eric Weaver. He's in Albany, California. His home phone number is no, I'm playing. Eric, I'm not going to give you your home phone number, but his office number is 510-524-2355. I'll never forget that number. But he's solid. But if you end up having to represent yourself, there are steps that you'll go through. Like in the Eastern District Court, there's no time period that they can actually sit on your case. They, for an example, they sat on mine for 30 months before they told me no. They told me denied, and the reasons why the court's decision was whatever it was, which didn't make any sense to either of us. But their opinion is their opinion. So then once that's denied, you have to file a certificate of appealability. That's a COA. Usually, all attorneys in the appellate district understand what that is. But a COA is requesting the Ninth Circuit to accept you arguing your case in the Ninth Circuit. It's just like when you file a petition for review in order to be heard in the California Supreme Court on your direct appeal. But this is with the federal courts. Now, the Ninth Circuit, they're an extremely busy circuit because they cover everything from, I want to say, Arizona north and everything west of that. So they're getting tons of petitions, and they're going to deny whatever it is they're going to deny, and they're going to accept the cases that they're going to accept. So there's really no time frame, so just be aware of that. Also, once you get to the Ninth Circuit, the ball rolls fast in the Ninth Circuit. It's not like any other court. They don't play around. They don't sit on it for years. They get in. They take both sides of the argument. They turn around, give a date for the attorneys to come and orally argue the case, and then give it a few months, maybe a year tops, and you'll have a decision. After that, then you'll file, let's say you're denied in the Ninth Circuit. That's before a 3-judge panel. You have the right for rehearing en banc. The rehearing en banc goes before 11 judges. My rehearing en banc I was granted, but then the opposition turned around and filed a cert motion to the United States Supreme Court. The United States Supreme Court has a right to deny or accept the cert motion by the opposition. If that is the case, then you're going to have your case argued in the United States Supreme Court, and good luck to you. But for the most part, as I've always said from the very beginning, you know your case. You're gonna have to really push the envelope for yourself, and depending on if you have an attorney and or you're arguing it yourself. And once you get into the federal court, then you're really gonna have to pay attention because the ball is going to move. The district court, they can sit on your petition for as long as needed. Once you get out of that court, it's showtime. The Ninth Circuit doesn't play. I can attest to that myself. It was a smooth process, but boy, was it a scary one. But I'm here now, and I'm looking to help everybody that needs the help. Hey, until next time, man, I got y'all back, man. Talking about spread the love and the word. Let's get it.